Hi, and welcome to the Law Simplified. I'm Shaveen Bandardanayake. This is a practical guide to learning equity and trusts. Whatever subjects you encounter in your study of law, it will fall into one of two categories. On the one hand, some subjects will be easier to understand and comprehend, and you can put a practical spin on it, so to speak. Others, on the other hand, will be a bit more difficult to comprehend, and you might have to put more time and effort in understanding it. Whichever category the subject you're preparing for falls into, you will encounter them in your day-to-day life as you go into your professional career. It might be something like contract law, criminal law, or even property law, where at one point in your life you will encounter it and you will have to tackle problems as it relates to it. One subject, however, that you may not encounter at all, or at a handful level, so to speak, would be equity and trusts. Because of this, it is somewhat difficult for many students, having taught both fast-track and masterclass students for many years, as I have gathered, to comprehend the application of trust law or equity and trust into a real-world context, something that they can relate to on a one-on-one level. Now, because of this, it is important to understand this subject as being broken into two specific stages, one of which is fundamental to the functioning of it, and the other how it's applied and manifested by law and practice. Firstly, we need to understand that, as the word in the law itself suggests, the entirety of equity and trust relies on the concept of trust. It relies on the aspect that people would do as instructed for the betterment of another person gratuitously. If, for example, we look at a subject such as contract law, we look at relationships that are built on a one-on-one basis because of consideration that is passing between the individuals. And when it comes to third parties to receive gratuitous interest out of it, it's quite rare and even then subject to major conditions. Trust law cascades and transcends this philosophy. Considerably, we are looking at three specific individuals when we talk about equity and trust. Three actors, as I like to consider them: the settler, the trustee, and the beneficiary. On the one hand, where in contract law the power lies with the parties who are party to a contract itself, in trust law it is the inverse of it. I would argue that the most powerful person in a trust is in fact the person who is not party to it at all, namely the beneficiary. This is the core of this subject. And on most occasions, students find it difficult to fathom, coming in from a common law subject such as contract law, to gauge how equity plays such a role in binding parties together, on purely, at times, word of mouth. Connected to this aspect is the requirement that this trust is substantiated by three certainties, namely, the certainty of the settler's intention, the certainty of the subject matter in question, and most importantly, the certainty of the object or the beneficiary. Who is giving it and what does he want? What is he giving and who does he want it to be given to? These are the three certainties that bind these parties together. The operation of these three creates what we refer to as an express trust instrument. There are a number of rules that govern this, and without going into too much detail, of which you can have a look through the links in the description below and the specific playlist on equity and trust on this very YouTube channel as well, the goal is to identify this fundamental requirement and the exceptions that exist in establishing other specific types of trust instruments as well. Now, mind you, the very nature of trust law is such that it will make a rule and break it when necessary, either by virtue of precedent case law or statute. So, for example, if we take the fundamentals or the foundations of trust law as the requirement of the three certainties, you can look at different types of express trusts which break these rules, still existing as exceptions to that rule. So for instance, if we take secret trusts, either in the form of fully secret or half secret trust instruments, what's missing might be the certainty of intention and the object, while the subject matter is subsisting. If we take something like a charitable trust instrument, a purpose trust, the intention is clear, the subject matter is clear, but there is no specific object, only a class of people. Each individual specific type of trust instrument is allowed because it provides something for the society as well as the individual. Going through each individual type of trust provides an opportunity for us not only to understand the subject of equity and trust, but also appreciate the thinking behind the decisions. Right, equity and trust is a subject that many students won't encounter in terms of their day-to-day lives, and as such, the inability to relate an actual everyday circumstance to it makes it far much more difficult to put pen to paper when it comes to understanding the concepts and applying it to any given scenario. Having said that, a good rule of thumb is to understand why trust exists, how it exists, and what exceptions are there in order to facilitate different types of trust instruments. If you'd like to set up a one-on-one fast track or a masterclass program to go in depth into this particular subject, make sure you reach out through the links in the description below. You can also get access to comprehensive pre-recorded masterclasses and fast track programs through my online law school platform, where you can get access through the link that will appear on screen right now. But until the next time that we meet, have fun, stay safe, and as always, obey the law.